Under federal bankruptcy law, death does not automatically end every bankruptcy case. But what happens next depends a lot on the chapter you file and the timing. Hi, I'm Perlman. I'm a consumer bankruptcy attorney. I've been helping consumers and businesses get a financial fresh start for over 30 years. But before we talk about bankruptcy, terminal illness, and if somebody dies during the process, I want you to know that reaching out to a bankruptcy lawyer does not mean you're filing bankruptcy. It simply means you're trying to understand what your options are. If you find this video helpful, make sure to like, share, and subscribe, and contact our office if you have any questions. When people think about bankruptcy in this situation, medical debt is often part of the picture, but it's not the only factor. Medical bills can stack up fast, and the broader burden of the medical debt in the United States is significant. It has been estimated that in 2024, Americans owed at least $220 billion in medical debt. But when somebody is terminally ill, the real question is bigger often than medical bills alone. Families are usually trying to figure out whether a filing now could protect the surviving spouse, preserve important assets, and stop unsecured debt from swallowing up what little financial stability is often left. Timing can be very critical in these cases because filing before death, filing after death, or not filing at all can lead to very different outcomes. So here's the first big point that I want to make today. If a person dies before filing bankruptcy, the bankruptcy estate generally cannot start a brand new personal bankruptcy case for them. This is why waiting too long sometimes can close off options that might have been available when the individual was alive. Now let's talk about what happens if somebody files a bankruptcy and passes away before the bankruptcy concludes or discharges. If the case is a Chapter 7, the rules are generally more favorable for seeing a case to its conclusion. That's because Chapter 7 is a liquidation, so the trustee has the ability to administer non-exempt assets even if the individual is deceased. If everything is handled properly, eligible debts can still be discharged, which releases the debtor from personal liability on their discharged debts. If the debtor dies before the meeting of creditors or the 341, someone may still need to step in and help move the case forward, provided the case has not been dismissed by the trustee. Chapter 13 is different. Chapter 13 is a repayment plan that typically lasts between 3 to 5 years. So when the debtor dies, the court has to look at and the trustee has to examine whether the case can continue in the absence of the debtor. In some cases, depending on the facts, the court may allow the case to proceed. In other cases, it may require that the case be dismissed. And in some cases, you can make an application for a hardship discharge if the legal requirements have been made. That is why timing and chapter selection matters so much in the context of bankruptcy. There's another very important point that I'd like to make today. Bankruptcy only deals with debts that are part of your case. Bills that are incurred after the filing date or post-petition are not part of the bankruptcy estate and cannot be included. So, if someone is very sick or terminal and they're getting existing treatment, the timing of the bankruptcy case can be very important. If you are in New Jersey and unfortunately dealing with a stressful situation surrounding someone's terminal illness, this is not the time for guesswork. The right advice can make a major difference for you and your family and their financial well-being. If you're facing financial difficulty, don't hesitate to reach out to my firm for a free initial consultation. Remember, seeking the services of a bankruptcy attorney doesn't mean you're filing bankruptcy. It simply means you're trying to understand what your rights are.